weather. Request for bill introductions, we're going to start off with. Today is the last day that we can introduce bills in this committee. Tomorrow's the deadline overall, but since today's our last meeting before the deadline. So do we have any bill introductions from the committee? Representative Neely? Oh, no, okay. None from the committee. Do we have any from the public?
Hi, good morning. Thank you, Mr. Chair. Kelly Vanswall on behalf of Kansas Bankers Association. I'm requesting introduction of 26 RS 3168, which would relate to social media and telecom fraud prevention.
Okay, committee, do we have any questions? Any objection? Seeing none, thank you so much. Do we have any other bill introductions from the public? Seeing none, we will move on. Our first item of business today is opening the hearing on HB 2590, and we will turn to David. Oh, okay, sorry. Jason for the overview.
Thank you, Mr. Chairman. Good morning, committee. Jason Thompson, Revisor's Office. You get me today because this one is trusts. So, hey, kind of judiciary. You have a fairly lengthy bill brief. I'll try to just hit the high points and let the conferees kind of fill in some more of the details. Since it is about trust, it is fairly technical, and I'm a general practitioner, not a trust specialist. So we'll dive in. It enacts the Kansas Community Property Trust Act, which authorizes the use of community property trusts during the marriage of settler spouses. It also amends the Uniform Trust Code to allow trustees to reimburse settlors of grantor trusts, to also authorize the use of designated representatives for trusts, and finally to permit the terms of a governing instrument to expand, restrict, or eliminate certain general rules that are applicable to fiduciaries, trusts, and trust administration. Section 1 is the first of 9 sections that establish the Kansas Community Property Trust Act. It also provides definitions, so if you want to know about community property or what one of these trusts is, you can look in Section 1. Section 2 actually provides what arrangement is a community property trust, and it has some specific statutory requirements. Essentially, it has to expressly declare that it is a community property trust. It has to have at least one trustee who is a qualified trustee and exercises certain powers related to tax filings or tax returns. It has to be signed by both spouses, and it has to contain certain language that's actually in the statute about the consequences of the trust being very extensive and that careful consideration is advised. Section 3 then puts a list of matters that may be contained in the agreement establishing a community property trust into statute. It also provides for amendment of the trust, either by the terms of the trust itself or by a spouse dealing with just their half share of the community property. That section also, I should point out, specifies that a community property trust may not adversely affect the right of a child to support. So there is a limitation there related to support. Section 4 talks about how spouses may transmute all of their property or any of their property to community property by transferring it into one of these trusts. Even if neither spouse lives in Kansas, they can still use a Kansas trust and Kansas folks to do this. Section 5 talks about an obligation incurred by only one spouse before or during the marriage may be satisfied from their half share of one of these trusts. An obligation incurred by both spouses during a marriage may be satisfied from the community property trust of both spouses. Section 6 then has some tax language, purposes of certain tax code. It is a trust established under the community property laws of Kansas. Section 7 provides that upon the death of the spouse, half of the property that was in there is the share of that surviving spouse, and it's not subject to disposition by the decedent spouse or distribution under succession laws. The other half is the share of the decedent spouse, and it is subject to all of the dispositions and disbursements. And there's a bit of other language in there about what happens when one spouse is deceased. Section 8 provides that on dissolution of the marriage, so divorce, The community property trust shall terminate, and there is distribution of half of the assets in accordance with the section. There are some special timing rules in there depending on, how long the action is pending, whether it's resolved, and what happens with the property. It could also be provided in the terms of the trust what will happen, but essentially if the marriage ends, the trust has to end. It's one of the requirements of the trust that the spouses are married. Section 9 provides that is the last one of the new act. It provides that a community property trust executed during a marriage is not enforceable if the spouse against whom enforcement is sought can prove one of the elements listed in that statute. Basically, that they didn't know what they were signing or that it was involuntary or something like that. But there's a specific criteria there in the statute. Section 10 then is a new section of law unrelated to the first 9. So it is about the Kansas Uniform Trust Code and designated representatives. So we're shifting to the other topic of the bill. Designated representative is defined in the section. That's a person who has delivered to the trustee their written acceptance of the office of designated representative or otherwise agreed through service or action to serve as designated representative following appointment to act as a designated representative in at least one of the manners specified in the section. So this is a person who has agreed or been appointed to do the designated representative duties. There are a number of reasons that you could be appointed. A couple of them would be you're representing a minor beneficiary, an unborn beneficiary, someone whose location is unknown, or you're appointed a beneficiary by another, or you're appointed by a beneficiary to represent them. So those are just a few examples of why this might be used. Section 11 is related to Section 10. It also goes into, there's references to Section 11, but it's not directly related at this point. Section 11 is another new section that would be in the trust code, and it provides, notwithstanding any other law, the terms of a governing instrument can expand, restrict, eliminate, or vary from general applicable rules to fiduciaries, trusts, and administration. And it gives a whole list of things that the trust can vary from. Essentially, it's putting in a sentence from the statute, the policy to give maximum effect to the principle of freedom of disposition and enforceability of governing instruments. So that's what the first big chunk of Section 11 is. And then the second part of Section 11 is that if a governing instrument restricts the right of a beneficiary to be informed of their interest in a trust, for example, a minor not knowing about what is in the trust, the designated representative that we were just talking about in Section 10 can act, shall act in their capacity, and they will represent and bind that beneficiary for purposes of judicial proceedings and non-judicial matters. So that's kind of how the two sections are related eventually. And then there are 3 amendatory sections, all in the Uniform Trust Code. Section 12, the change there is to deal with tax when a trustee's discretionary authority to exercise or to pay directly or reimburse the settlor for any tax or trust income that is payable to the settlor is not considered an amount that can be distributed to or for the settlor's benefit. And so creditors or assignees of the settlor are not entitled to reach that amount solely because of that discretionary authority. This obviously has implications for creditors and tax. I won't get into too much of that because I just can't explain it very much more than what the statute says. Section 13 then is an amendment to the current law that just provides an exception to the rule that beneficiaries have to be informed of information about the administration of the trust. And the exception is for when the governing instrument says the beneficiary is not going to be informed. For example, I think when we were drafting, we talked about a minor who is just not told how much money is there. They have a designated representative who controls everything, and they find out later what's going on with the trust. But for purposes of the trust, they've been told they can't find out information, and this would make clear that that is allowed and allow that to happen. And then the last section adds a new provision to the long list of powers that a trustee may exercise under the Uniform Trust Code. And it is, again, another tax provision. A trustee may exercise the discretionary power to reimburse the settlor for the portion of the settlor's income tax liability attributable to the trust under specific federal tax laws. So that's what that one would add. It would take effect on July 1st. I think that covers everything, at least briefly. Happy to answer questions if I can.
Jason, thank you so much for that. Committee, did you get all that? We good? Any questions for Jason?
The good news is you've got folks that can really explain this coming up. So
Representative Kahar. You want to wait? Okay, not a problem at all. Coach?
Thanks, Mr. Chair. Could you just give a real brief on community property trust, what that would be?
Sure. Mr. Chairman, I'll try to give kind of the perspective I have just from the language of the bill, right? So community property, as most of you probably have heard, that's property owned like during the marriage of the spouses, right? And by putting it in this trust, you make it community property. And so you only have an interest in half of it, and the other spouse has the interest in the other half, and you can either dispose of it together or deal with only your half, or they can deal with only their half. That's kind of the community property concept. And this trust can only exist when the spouses are married. So that is one of the requirements statutorily for the trust to be valid. There's a number of other implications, but those are the two kind of basic principles.
Committee, any further questions? Seeing none, thank you so much, Jason. Shout out to the Kansas Bar Association for their appearance in my committee today. Joe, it's always great to have you here. I know. You're usually in this room, but it's not for this committee. So you're not here this early in the morning. All right, our first proponent up is going to be Kelly Van Zoll with the Kansas Bankers Association. Kelly, welcome back to committee.
Thank you, Mr. Chair. Good morning, members of committee. I'm going to talk very briefly and then turn it over to our expert here who deals in trust business every day. But in case you didn't know, the KBA also has a trust division. We've had it for over 100 years. We currently have 36 members. It's independent trust companies and then banks who have trust departments. When Will Bergman and Midwest Trust brought this concept to us, we ran it through our trust division, and they worked with him on it and ended up supporting it wholeheartedly. So you'll see the testimony from our trust division, but that's just a part of the KBA, in case you had any confusion there. Will's going to go into the details, but there's 2 points I really want to hit, which is one, in the past couple, I think in 5 years, we've done a variety of trust code bills in the Kansas Legislature, and since then we have tripled the trust assets that are managed in the state of Kansas. So thank you for voting and working with us on these. You guys are making a big difference for the industry. The other point I want to make is all of the provisions in this bill are optional, meaning that both the drafter of the trust and the grantor, the settler of the trust, are going to have to say, yes, this is what I want to do. They're going to have to either opt in or put specific language in. None of this is going to accidentally slip into someone's trust unless they've consciously made that choice. So I just want you guys to think about that when Will's explaining the details. So I'll hand it over to Will Bergman now.
Will, welcome back to committee. It's great to see you again, sir.
Mr. Chairman, it's always a pleasure. My wife gets tired of me talking about this, so thank you all. Members of the committee, thank you so much. And also, Jason, you equipped yourself super well. That was amazing. I know it's really technical. It's a lot of work. The staff's been amazing to work with, so thank you all for that. So from a high-level perspective, you guys have seen a lot more trust bills over the last few years, just as Kelly was discussing. And that is because we are in the middle of the largest wealth transfer in the history of humankind. And so as the boomers are starting to retire and as their parents are passing away, we're in the middle of what is going to be this massive change in both how assets are titled and how money is transferred. And then also we are on the piggyback of COVID, where people are much more comfortable talking to and having communication with their financial advisors, with their trust officers, with their bankers, with all the people, their accountants, over Zoom. And so these two factors are leading to why there is this influx, this positive, hopefully for a positive reason, to help better our clients. And so we are trying to have Kansas be equipped to be the best state to administer trusts in. As you can see, we've already tripled assets in the last 5 years. This is happening, and it's going to continue to happen rapidly. So in Kansas, we are now administering trusts for people who live in all 50 states because of what we just did. Last year and the year before, you worked on the originating trustee statute. I'd like to thank you all for allowing that, for working through that. That actually allowed for Midwest Trust Company to acquire a trust department in Dallas and in Texarkana. And so directly because of that law that you all passed, we are now servicing people under our Kansas charter in Dallas and in Texarkana. So thank you so much for that. And then when we are looking at the number of trust companies that are being formed, we actually hadn't formed any trust companies. I think it had been in the mid 2010s, and then we're in the middle of forming about 5 or 6 other ones. These are good, high-paying jobs where people a lot of times have law degrees, or they have CTFAs or CFPs or CFAs. These are really highly credentialed people, because what they're doing is they're taking on highly technical and highly specific services for families, because we step in. When someone passes away and there's an estate plan that's drafted, or no estate plan, and goes through probate, oftentimes it's attorneys, family members, or trust companies or banks with trust powers who step into those roles. So we take on everything. So if it's real estate, if it's oil and gas interests, if it's their cars, their houses, their vacation homes, their IRAs, and we are actively interacting with that. And so then when we're thinking about how do we best take care of our clients, we want to be able to have the right tools and techniques in partnership with the estate planning attorneys, which is the Bar Association, which Joe represents, and we want to be able to provide the best services. Because I'm sure you guys all have heard on your commercials, or seen commercials, or listening to radio commercials about fiduciaries, like how they're obligated to do what is in their best interest of their clients. Trust companies are the truest fiduciaries, because we take everything, not just the investments. There are 17 duties that we owe to our clients. And so part of that process is we are advocating for bills and legal changes to help better the way we support our clients. And then getting into the granularity here, and thank you all for talking about the Kansas Community Property Trust. So Midwest Trust Company has an office in Nashville, Tennessee. We have 2 trust officers, both with law degrees there. We are currently administering community property trusts under the laws of Tennessee in Tennessee for Kansas residents. That's not what I want to do. What I want to do is be able to attract business from across the United States to Kansas utilizing this opt-in provisions. As Kelly was saying, is this community property is an opt-in tool. So the estate planning attorney has to proactively draft this document for their clients. And when we are administering a community property trust, it has the best tax situation. For example, my grandparents would have been perfect for this if this had been around before they passed away. They were married for 65 years. My grandfather passed away 10 years before my grandmother, and normally that happens in most relationships. The woman in our business, we know that about 62% of the time, the wife passes before the husband. In that period of time, if we'd had the community property trust, would have allowed for a double step up in basis. So we now also have the estate tax exemption really high. I'm sure you guys might have seen in the OB3 bill that the estate tax exemption has raised to $15 million. This is the first time in my career where it affects a negligible amount of clients. So now what we're trying to do is, instead of in the early 90s when everyone had estate tax problems, we are now trying to maximize the value of the dollar underneath it. And the best way to transfer assets is through a step up in basis. And that's when someone passes away, their basis gets reset in the asset at their date of death. And so this technique is highly valuable, really efficient, and really effective, and it's tried and true. So, and you only utilize it for married couples who've been married for a really long time. If there's a prenup or a postnup, it doesn't apply. And as Jason mentioned, there's protections for children as well. It's a really good and effective tool. But again, it's not a tool, it's not a panacea, it won't solve all the problems. So that's kind of an overlay of why and how we are going to utilize community property trusts. And so that is all new. And then everything else is actually kind of how do we adjust trust agreements as a whole. And so one is with the designated representative, and then the enumerated changes and governing instruments. Those ones are kind of linked because it allows the grantor, the person who's establishing the trust, to have more discretion and to say, I want to achieve this with my kids. Right now, all of the laws that affect how trusts are administered were all basically created in the early 90s by a joint committee that was of estate planners across the United States. And then in Kansas, we were actually the first state to adopt the Uniform Trust Code. So if you look in the history of trust bills, a lot happened in the early 90s, and a lot have happened in the last 5 years because of those the factors I was talking about earlier for the recency in the early 90s. And so as we are trying to say, how has life changed since 1990 to 1994? And then how are things changing now? And then what are we going to need to do in the future? So what we're trying to do is give people more optionality, because I don't know their family that well. The estate plan attorney doesn't know that family that well. But the person whose assets they are knows their family. So we're trying to give them the tools to be able to do that. And so that's why sections 10, 11, and 13 are really important, because together they read in and allow for people to come up with the best strategies for themselves. And then on sections 12 and 14, these are giving more powers to the trustee. So this is one where the trustee has discretion. Again, it's optional, and they can reimburse for taxes. And so a lot of people used really aggressive estate planning techniques. And now they need a reimbursement because they have no assets outside their trusts. And so this was a request from some estate planning attorneys in Topeka. And all of these things, all of these bills have, we've had communication with the Legislative Council and the Bar Association. And so we've worked together to collaborate to try and bring Kansas to the forefront of the trust and estate world. And to conclude, I was just at the largest estate planning convention in the US. Like it was like Comic-Con for estate planners, like really full of nerds. And there were 6,000 people. And when I talked about what we've achieved over the last 5 years and what the outline of this bill was, many estate planning attorneys said, oh, wait, maybe I need to start thinking about creating reciprocity with my bar association license to Kansas so that I can start utilizing these tools and techniques. And so that is exactly what I'm hoping for, because in the future, in 30 years, there'll be some states with 0 trust companies, there'll be a handful with a lot of them, and I just want Kansas to be successful. So I'm happy to stand for any questions.
Thank you, Will, for that explanation. I have a quick question. Because of the bill just getting introduced last week and we're hearing it today, we haven't been able to form a fiscal note. Do you see any reason why this would put excess cost on any state agencies?
No, I would guess it would come in at 0. This is entirely going to add assets to the state and allow for trust companies to add more jobs. It might, and then that'll lead to higher assessments and privilege taxes for the state.
So in a roundabout way, it will bring money.
It'll bring revenue in.
Okay, thank you for that. Committee, do we have any questions? Representative Bohai.
Thank you, Mr. Chair. Thank you so much for your presentation this morning, Will. My question is, you referenced Tennessee, but are there other states that we are trying to make sure that we are as competitive as possible?
Yeah, so that's a fabulous question. So Kansas has 12 or 13 trust companies right now. South Dakota has 121. That is a crazy difference for a state that has a third the population, to half the population. And that's because they have marketed themselves nationwide to the coasts and to the rest of the Midwest to try and attract business. Delaware, for instance, has it's close to 50 trust companies. And so when you talk to estate planning attorneys, they know that they're safe choosing those situses. So we have been educating, going to conferences, talking to these people to try and achieve that. And so I want Kansas to be seen at the same level. And I think we're getting really close.
To build on that question, if I could, is it fair to say that passing this legislation actually increases competition to you guys?
Competitive landscape for the nation? Correct, 100%. Because I don't have to go and pick off, because Midwest Trust has offices in Ohio and Tennessee, which have a couple really like community property trusts are in Tennessee. So we have to go there. And so we have to hire staff there and have backup for staff there. And so we are trying to be able to achieve all those goals, to be able to service all these clients and just say, yes, I have an answer, it's Kansas. It's gonna be in our Wichita office, it's gonna be in our Overland Park office, it's gonna be in our Onega office. And that's what we want to achieve.
Representative Shu.
Thank you, Mr. Chair. This is, I guess, a little bit of an aside, but I think estate planning generally has kind of like a high net worth kind of indication, but do you see more middle-class families kind of engaging in this recently? I know my wife sends me TikToks like all the time being like, hey, we got to put our stuff in a trust. And so when we pass away, like it's easier to pass it on. Do you see any trend in that?
Yes, so I actually think, about 4 years ago, we raised the small estate affidavit up to $70,000. It had been stuck at like $35,000 for a really long time. And so that's really helped out families with less than $70,000. I do a lot of presentation, continuing education for like mothers groups, people who are parents of young kids, and also of people who their kids are turning 18. There's a difference when your kids are a minor versus when they become a major, when they become 18. And you have different rights. Like if they have a medical event and they're off at school, you need to be able to communicate with the doctors. How do you do that? How do you prove that? You don't need to travel down there to prove your next of kin. And so estate planning, and also I think that some of the like how much more information is free flowing is going to be happening more and more. And I'm seeing my cohorts, my friends and people in their 30s and 40s starting to get estate plans more because the rules that govern what happens if you don't have an estate plan is called probate, and it hasn't been changed in about 130 years. And so these rules that we created don't necessarily affect how we live in a modern time. But it's hard to change those when you can just go out and have a small document. But that's a fabulous question. I love talking about estate planning. I think it's really important because I've seen all the terrible ramifications of not having one.
Coach.
Thanks, Mr. Chair. I got a couple farmer friends who feel like when their parents die, they'll have to sell the farm because it's taxed too much. Does that question make sense?
Yes, and so that is exactly why this is important. So my grandfather was a tree farmer before he passed away. And we are now dealing with his assets, his tree farm. And dirt rich, cash poor, just like your friends. And so he passed away 7 years different than my grandmother on that side. And if he'd actually put it in a Kansas Community Property Trust, it actually would have gotten a double step up. And so it would have allowed us to distribute, because $30 million and $15 million is a crazy amount of money. And so if they can maximize it underneath that $15 million, get an appraisal, get the double step up, it can allow for them to not have to sell because they have a new tax basis. That's why the estate plan or estate tax is so terrible for farmers, because it requires them to sell, or you have to take a loan out and there's not enough cash flow. And we see that with our clients across the US, and I saw that with my own family. And so hopefully, and I'd be happy to talk to them about that, because unless it's $30 million or more, in which case it's only incremental dollars over 30, we should be able to come up with a plan which prevents them from having to sell it, right? These goals are to allow people the choices and the options, not the requirements.
You good, Coach? We're good? Okay. Representative Kahar.
Thank you, Chair. When a minor is included in a trust, I think they touched on that earlier, where someone chooses an appointee to represent the minor. Is that up to the grantor in the trust or the person creating the trust to decide who will represent the minor going forward? And then I had a follow-up question after that as well.
Okay, great question. So we have, under the rules that were established in 1994, it's under 58A 505. It basically establishes who are qualified beneficiaries, who receives statements, who receives notices, who can request a copy of the trust. When someone's under 18, they're not considered a valid remainder beneficiary. It has to be through a guardian, or there could be a guardianship, or there's some other structure. And so we already have rules in place for that. And so they will just receive it underneath those standard rules. What this allows you to do is when they're a major, or you can actually designate someone to receive those statements, which is equivalent of someone having a guardian. So yes, it keeps with standard common law practices.
The next question had to do with the spouse and how that lines up. I really appreciated how you said, maybe it was Kelly, mentioned how it was very customizable. Does it leave the option to where you could have, where say there's two spouses, but then they want their kids in the trust, where if one spouse is still living, 100% goes to that spouse instead of just 50%, and then when that spouse is deceased, then it goes to the kids? Or does it just, would that spouse only hold 50% and then not be able to sell?
That's a really good question as well. And that's the important part. So there's two different, from a high level perspective, there's community property states and there's separate property or equitable distribution states. And Kansas has traditionally been a separate property state. And so it allows for, if you have a gift, or if you have a prenuptial arrangement, or you receive, but all W-2 income comes into the marital estate is what it's called. And so under the community property trust laws, it actually can be adjusted, but both have to agree. And so there's also, you can have revocable trusts that are in the name of the husband and in the name of the the other spouse, the wife, and then you can also have joint ones. So it basically allows you to take those same structures between your standard revocable trust and put it in a community property trust overlay. And so it allows for the same flexibility to allow for the kids to be considered beneficiaries or for them to be trustee as well.
Representative King.
Thank you, Mr. Chair. Will, you said South Dakota has 120 some trusts. If we would call our friends in South Dakota, what would they say benefited the state and the state finances the most?
So they have created something called the Governor's Task Force. And so the governor sits on a task force with 3 or 4 different estate or trust leaders, estate planning attorneys. And I think it's been a significant boom. As you know, in the 80s, they eliminated usury rates, which is why all your credit card statements are held out of South Dakota locations. And they've actually required you to have physical presence in the state. And so it actually includes that as well. So if you're going to be a corporate trustee and utilize some of these laws, you are going to have an office in the state of Kansas. And that will benefit the state of Kansas, increase property taxes, high-paying jobs. And so right now, to hire a trust officer in Sioux Falls versus Kansas City versus Chicago, Sioux Falls is the most expensive market because they've attracted all these out-of-staters. Like UMB Bank, one of the biggest local banks for Kansas and Missouri. I think it's a national charter. They have a national charter and a South Dakota charter. They don't have a Kansas charter. And when you look at National Advisors Trust Company, a big national trust company that's headquartered in Kansas, they have a national charter that does not help the OSBC, does not help create regulations here, and they have a state charter in South Dakota. Wells Fargo, state charter in South Dakota. So they have made these decisions, and the state has created a relationship with these banks to bring the jobs and then to bring the business. The biggest trust company headquartered in South Dakota is 50% bigger than all of the industry in Kansas. It's $300 billion. And we're now up to 170-ish billion. And that's a major difference over the last 5 years. But I think we are going to continue to grow more rapidly because we have got 2 amazing law schools in the state. And we also have a great financial services background leading back 160 years in this history of the state. So this is, I know for our organization, we have 300 high-paying Kansas jobs, and that's 1 or 4 of the trust companies. That's not the other 45.
Thank you, Mr. Chair.
Representative Roser.
Thank you, Mr. Chair. I just have a quick question. You talked a lot about South Dakota, and I looked into that case, and it looks great. It's been almost 30 years since it was passed in Alaska, and then was passed, I think, 25-ish years ago in Tennessee. Can you talk a little bit about how that's going in those 2 states?
Yeah, so Alaska, there's a guy, I'm blanking on his name, but he was like, I'm going to make Alaska the best trust situs in the U.S. And there are a bunch of, I don't know how exactly off the top of my head, in Alaska, because they made asset protection trusts, they made community property trusts, and so a lot of the West Coast people have their trusts. If they're if they're a California resident or a Washington resident or Oregon resident, they actually choose Alaska. And then in Tennessee, part of the reason we opened up an office in Nashville was to avail ourselves of the community property trust statute there. And and then now I know of a lot of estate planning attorneys in Lawrence and in Wichita who actually draft Florida community property trust laws. So they take the assets of a Kansan and it's administered, and they hired a trust company, which then has accountants, which then gets regulated down there to Florida. And what I'm trying to do is prevent that from happening. And so we do this in Kansas. But Tennessee is it's a aggressive estate planning place. I think Kansas is better now if these get passed because we've got better rule against perpetuities, better decanting statute, and it's structurally very similar besides those 2 things.
Coach.
Thanks, Mr. Chair. I know a trust, I've always heard they're a good thing. I've always heard a probate is a very bad thing. How is a trust better than a will?
That is a great question. So a will is the oldest recorded way to transfer assets. And I think there's something called nominative determinism, which is your name determines what you do. My name is Will, so naturally I went into estates and trusts. But a will is just a document. It has to be signed and executed, and then you take it into the probate office. And so when you do that, you submit it, and then you have a creditor claim period. And this is why it's not as good. A will is not its own legal instrument. It's a transfer document. It's like when you are jointly titled, if you're jointly titled on a bank account, right? It transfers to your spouse or someone else who's on the same bank account. But a will goes through probate. It has a creditor claim period where other people can say, actually, before you pass that money on to my next generation, you have to host, and you could have debt on your house, you could have credit card bills, and those go attached. But a legal instrument like a trust, which is its own entity, immediately transfers it because there's someone else already in charge. So when Midwest Trust steps in, and Midwest Trust is trustee of a trust, and you sign it in someone's office, you come into our office, you execute with the estate planning attorney, you hand over the document and the assets, it exists immediately. And it's not public. That's a big reason as well. Probate, you can search it, so you can see what your neighbor owns, particularly for your friends who are farmers. That's never good, because then they could end up getting a lowball offer from their neighbors because they know exactly how much assets are there. But with a trust, it is fast, it is cheaper than probate, and it is anonymous. And there are a lot of rules that are in statute that govern trusts. Well, a will just passes it on outright. So we do a lot with special needs beneficiaries. Midwest Trust is very proud to provide services to people who have had tragic accidents or have special needs. And so there are special rules that govern that. And so some of these trusts might last for their entire lifetime if there's enough funds. And that is not something you can do with a will. Trusts are flexible. Well, wills are stagnant and inert.
Representative White.
Thank you, Mr. Chair. I'm getting a sense of there is competition among states. How many other states are hearing a community trust bill this year?
So there are only, I think there's 5 that have passed it. I'd guess there's only 1 or 2 other ones. This is, because it's been proven in Tennessee, it's on the cutting edge. And now the estate planning attorneys, like, as I said earlier, I think there's only gonna be maybe 8 or 10 states in 20 years that have trust companies headquartered in the state. And then there'll be national ones. And if we continue at the process we're doing in Kansas, we will be one of them. Like South Carolina has 0 trust companies. And I don't think they ever will have one. But they have banks that have trust powers that are there. But as we know, banks are being merged, community banks are being merged, and they're being pushed. But trust companies are a different business. So yes, I think there's so it's in Florida. It's actually, I think I listed it in here. Florida, Alaska, Kentucky, South Dakota, Tennessee, and the only other one that might be doing it right now is Wyoming. But that's it. But again, Wyoming has been on the forefront as well.
Thank you, Mr. Chair, and thank you.
Representative Rivas.
So my question is a little bit off the bill. So it sounds like there's been a lot of legislation passed in the last few years, and then now we have this one, so it's like building blocks. So what is not in this bill, or what's coming down the pike if we pass this? So what's the next step? Because I know IRS is always changing rules too, so.
Exactly. So this bill is a direct result of the estate tax being so high. For the longest time, we had been planning on how do you maximize the value. We had a lot of life insurance in trusts. There's called irrevocable life insurance trusts. That was very popular until about 2007. And then when the estate tax exemption jumped up to 7.5 in 2012, I haven't seen one of those drafted except for someone who's a centimillionaire. And what we've done over the last few years to allow it is we've reworked what the definition of a resident trust is. We've allowed for dynasty trusts under rule against perpetuities. We have decanting, and like we are top. There's rankings of different states, and we're gonna be within the top 6 after we do these things. But the thing is, the difference between like 1 and 6 is immaterial for a lot of people, but it really matters for the people who are billionaires. And so what we're doing now is we're trying to make it great for everyone 0 to $100 million. And then if they need to create a private trust, like private trust companies are becoming very popular because you don't trust your accountant. So that's something that might be coming through, allowing trust companies to be LLCs because there's the shareholder limit is also something else that I could see that's been very popular with states. And so a lot of it's, again, it's still structural, but opt-in components.
Committee, any further questions for Will? Seeing none, thank you so much, sir.
Thank you.
All righty, that's all we had for in-person proponents. We do have one written-only proponent, Charles Andres. He's an attorney out of Olathe. I see no neutrals or opponents. Would anybody from the public like to speak on HB 2590? Seeing none, we will go ahead and close that hearing. Committee, we're going to jump into some final action on bills previously heard. The first bill we're going to discuss is HB 2497. Let's see which reviser wants to just give a, David's going to give us a quick overview of HB 2497.
Thank you, Mr. Chairman. House Bill 2497 is the bill that would amend KSA 16-207 to state that no prepayment penalty shall be assessed against any party more than 6 months after the execution of a note evidencing a home loan that's made primarily for personal, family, or household purposes secured by a real estate mortgage. In current law, the limitation personal, family, or household purposes is not in there. That would add this. So then prepayment penalties cannot be assessed for those purposes, but would be potentially allowed if it's a loan for business purposes.
All right, committee, do we have any questions for David? Seeing none, do we have any amendments? Seeing no amendments, we'll open it up to discussion and a motion. Representative Shu.
Thank you, Mr. Chair. I just think that where we are as a state in terms of housing supply and housing affordability, that this bill just goes in the entirely opposite direction. I'm sure a lot of you guys have similar experiences to me where my friends are putting in bids significantly above asking price and unable to get houses. And what this bill essentially does is it gives flippers and commercial investors kind of a discount for allowing a prepaid penalty to compete against our constituents and friends for the very same houses. And that's just going to increase prices overall too. So I can't support this. I just think it just goes against what the affordability conversations we've been having.
I would say just a kind of counter on that, they may get a discount on the interest rate, but they still have the prepayment penalty, and that's kind of just an option. I think at the end of the day, it almost comes out as a wash. It's just, do you want that flexibility or not? And how I view it is, yeah, to your point, there may be some of that happening. But a lot of this too is most of the renters in the state or the rental households are people that have 3 or 4 rental properties, and it's just passive income or it's a retirement plan. I know a number of small business owners in the Wichita area that have 2 or 3 rental homes because they don't really have a retirement plan, and that's kind of how they plan on retiring. So this would apply to them. Representative Weichel.
Thank you, Mr. Chairman. I echo the sentiments of the ranking, and I just wanted to share some information with the committee that I followed up with Rocket Mortgage with some questions after the committee. During the hearing, there was a statement made during their testimony that in exchange for accepting a prepayment penalty as part of their loan terms, they receive a lower interest rate. And so I asked follow-ups of what that really means. And what Rocket Mortgage provided to me said that in the current, they gave an example that in the current market, a corporation would receive an interest rate about 1% lower than a non-corporate buyer. And that I asked if that was for the life of the loan or just during the period where they're subject to the prepayment penalty. And the lower interest rate is for the life of the loan. So if they have a penalty, if they pay off within the first 5 years, but they don't, they keep the property, they continue with that lower interest rate for the life of the loan. So I just did a little bit of math on a mortgage calculator on a $350,000 house, assuming a 20% down payment. And the difference between a 6% mortgage rate and a 5% mortgage rate is $175 a month less for the corporation to own the house and over $63,000 less in interest over the term of a 30-year mortgage. So I just don't think I can support a bill that seems to make it cheaper for corporations to buy houses than for families.
And if I can ask you one concern, you hinted at, you said corporation, and you kept using corporation. But this again would also apply to just the rental property owner in Wichita or Johnson County that has just a couple of rental properties as well.
Mr. Chairman, maybe we can ask for clarification from the revisor. My understanding was that it would be any
I mean, corporations are included.
business entity that was buying it. So my understanding was that I couldn't go buy a second home as a rental property as an individual and receive this lower interest payment, this lower interest rate.
But if you're, I guess, structured as an LLC, you could.
Yeah, absolutely. And again, I think that I can't support a bill that lets
No,
businesses
Yeah, I understand
buy at
that.
a lower rate.
Yeah, just clarification on the corporation piece. Did I see Representative Bohai, did you have a?
So yes, so my question, I guess, stems from.
Is it a question or a comment for the discussion? If it's a question, who's it?
It's a question, a comment for the discussion?
Who's the question director?
Probably you.
Okay.
Thank you, Mr. Chair. Okay, so more than 6 months after the execution of a note evidencing a home loan made primarily for personal, family, or household purposes. Where do we define that?
That would be a question for the revisor.
Thank you, Mr. Chair. Yeah, I believe that's in the code someplace, but let me find the specific definition.
Okay, we can get that out. Committee, are there any further questions or discussion? Representative KR.
Thank you, Chair. I was wondering, two questions. One is if anyone opening an LLC, which takes about 15 minutes through the Secretary of State's office, would qualify for the business loan, and then generally how interest rates compare right now for business loans versus like a personal.
That would be something we would have to dig into, especially on the interest rate side. I don't have those numbers right in front of me, but that's some feedback we can get from the proponents of the bill. Representative Roser.
Thank you, Mr. Chair. I have a couple comments on this bill. I was snowed in the day that we heard this last Monday, but I don't know if anybody else on this committee has worked as a lender, but I have. I happen to know a lot about banking and have a pretty extensive banking history. And so looking at this bill, all I see right now is this is about fairness, not the punishment of lenders or consumers. It doesn't eliminate any prepayment penalties, not entirely anyway. Just in my opinion, Kansas borrowers shouldn't be locked in. So like, I guess when you're looking at job relocation or divorce, medical expenses, or falling interest rates, you shouldn't be punished for trying to improve your interest or your financial position. Also, I want to note that this does kind of align with the federal and state trends that we're seeing across the country. And it doesn't apply to commercial loans. And I've worked with both. I've seen all sorts of different lending and changes, and having worked in the industry, I just don't believe that this is something that's going to really punish your small borrowers for homes when we're looking at the housing issues in Kansas.
Yeah, real quick, Representative Schiff.
Yeah, respectfully, so this keeps the status quo of not allowing prepayment penalties for regular like home mortgages. The only thing that it does, it takes away the prohibition of prepayment penalties for commercial buyers, and they're doing that in exchange for a lower interest rate. So this bill only changes for commercial loans, just for clarification.
Representative White.
Thank you, Mr. Chair. This This bill, as I understand it, is, we gotta think about our bankers and our banks in this state, and they do credit checks. It doesn't matter if it's an individual or a corporation or whatever. Can they repay that loan? If I go in and take a loan out, one of the first questions I ask is prepayment. Is it a month's interest, 6 months interest? We have to, and I come from a very small community with small banks, and everybody tends to take care of themselves, but you have to understand, they have to ascertain a risk when they loan money, and I get it. Well, it doesn't matter if you're a corporation or a person. You still have risks. You still have a credit score. Thank you.
David, are we ready for an answer on that question?
Thank you, Mr. Chairman. Yeah, I mean, there's, in the Uniform Consumer Credit Code, when it's if it's for personal, family, or household purposes, those are then treated as consumer loans under the code, and those are which, it's if the, let me see. The debtor is a person other than an organization, and the debt is incurred for personal, family, or household purposes. It doesn't actually say, but it's pretty much just anything for like an individual debtor for their personal uses. It's pretty much anything that's not for business or investment type purposes that under an organization, a business entity.
Gotcha. Thank you for that. Representative Bohai, do you have a follow-up?
I'm missing how it's helping the corporations. Can you please help me figure that out? Maybe that's to ranking member.
Okay, it seems, well, I've got two. Do you want to go ahead? Okay, go ahead.
Yeah, so it's taking away the prepayment penalty, right? So it means that, or it takes away the prohibition on prepayment penalties. So that means for a commercial loan, the bank could say, hey, if you pay this off within 5 years, you pay a penalty. But if you don't, then we'll give you a lower interest rate in return. And so, maybe net neutral, that's a decision for the business, sure, but it will certainly make it more attractive, I think, for businesses. And again, I'm not really worried about that, but I am worried, again, there's already a severe shortage of houses in this state, and this just makes it much more likely that businesses are competing with our constituents who are looking to buy a home to own the home. That's what I'm concerned about.
Representative Bohai, you still have the floor. Okay, Representative Weichel, did you have something to add?
Thank you, Mr. Chairman. I guess the way I look at it, it's the commercial buyer would now have an option. They could say, I want a loan term that includes a prepayment penalty. And if they select that term, they will get a lower interest rate, regardless of whether or not they prepay it early. So they could have that lower interest rate for 30 years.
It almost sounds, the way it's being made out to be attractive here, that we should probably have a discussion on getting rid of the prepayment penalty prohibition overall. If that gives even people that want to purchase a home, their main residence, I mean, if they're going to get a better rate, maybe that's a discussion we should have at some time, is just removing the prohibition overall and allowing the markets to decide. Representative Roser.
Thank you, Mr. Chair. Okay, I'm better well read on the bill. Back on the commercial loans. So I worked in commercial lending for quite some time, and we had quite a few clients who were not necessarily house flipping, but trying to buy homes in my area, so the Manhattan area, but particularly in the central Wichita area. And I have this really amazing client, I won't say her name, but she was trying to get these houses so that they were livable again. So it wasn't flipping, it wasn't Chip and Joanna Gaines finding the worst home in the best neighborhoods and making them this spectacular Magnolia Farms deal. This is homes that, my friends and I were living in the freaking dumps of Manhattan, Kansas, trying to make it work, paying $200 each in rent in a 5-bedroom, 2-bathroom home, 5 girls sharing 2 bathrooms, absolutely insane when you look back on it. And so looking at this from a lending standpoint, absolutely do these borrowers need to be able to have this flexible choice. I mean, we've got people trying to flip houses around in 2 to 3 months, working with so many different local contractors. So now we're getting people employed and bringing these neighborhoods up to standard for what these people need to be living in. You're getting business, small business, and attracting small, like local area retailers. You're having business in title companies. You're having businesses with the commercial loan process. You're having business with all of the different contractors it takes to make this happen. I mean, it's not just about trying to find people homes, it's trying to find people livable homes. And a lot of these people who are investing in this commercial market are doing that, and we need that in Kansas. And so when we're talking about this housing shortage in Kansas, it's not just putting up new houses everywhere. It's not just lending out new consumer loans for different builds or new builds, you know, looking at what's happening on the outskirts of Wichita or what's happening in the Wamego area. This is also trying to improve existing structures. And so looking at this from a grand landscape of commercial lending, I can think of probably 15 to 20 different clients that I could call on my cell phone right now who work in small business, who work in trying to help with the housing industry and try to contribute to Kansas. And I can't think of a single person who actually works in this industry who would be against it.
Coach, did you have something?
Thanks, Mr. Chair. My question is for my representative friend from Manhattan. Pittsburgh, I think about 51% of all the homes in Pittsburgh are rentals, which is not really what we want. And do these people, these one-home buyers, do they have a disadvantage to buy a home? Because like I say, I see a house go up for sale and right away a conglomerate buys it. And they rent it to the college students or to the disadvantaged or whatever. And like I say, we want, you know, the American dream. We talk about the American dream, people owning their own house, but that's not happening in Pittsburgh very well. Thank you.
Thank you for that question. What I'm actually seeing, and especially with how this bill applies, when I go back to that client that I'm talking about who did this in Wichita and Manhattan, what she does is she buys these houses and she turns them around in less than 6 months and she sells them with the intention of selling them. So these, when we're looking at the pre-penalty or the penalty for paying it off early, that would directly benefit a business owner like her, who's buying these houses to do a short flip, trying to get it up to code, whether that's, you know, something as simple as repainting, redoing the window installation so it has better HVAC and all of those types of things, or just cosmetic. So that kind of client is who I'm referring to when I'm talking about this, are the people who are not renting it out. They're buying it to quick flip and sell it and make about 10 to 15,000. You know, they invest about 5 to 10,000, and then they make an additional 10 to 15,000 on these flips. They do it every other month. So you look at that, you know, they can pull a six-figure year just by doing a few short flips and working really hard to do it. I will say that these owners, or these people getting into this business, do have a very, very short stick when they start out. And so a lot of times their liquidity is not there to be trying to have additional properties to rent them out. So like being a slumlord, if that's what you're trying to refer to as like slumlords, they're trying to sell them to first-time homeowners.
Is it okay to say that you're a yes on this bill?
I know who I'm going to look at when I need a motion made, that's for sure.
Thank you, Mr. Chair.
Committee, do we have any further discussion? Seeing none, I do need a motion. Representative Roser.
Mr. Chair, I make a motion that the House Financial Institutions and Pensions Committee pass HB 2497 favorably out of committee.
And I need a second.
Second.
Whichever one. Doesn't matter. Flip a coin. Committee, do we have any questions or discussion on the motion? Hearing none. All in favor, aye? Aye. All opposed? No. Ayes appear to have it. Ayes do have it. Motion passes. All right, that was a really good discussion, committee. Great job with that. Up next, we're going to work HB 2515, and is that David again? All righty.
Thank you, Mr. Chairman. House Bill 2515. This is the Virtual Currency Kiosk Consumer Protection Act. This would become part of and supplemental to the Kansas Money Transmission Act. So this would govern those virtual currency kiosks where you can exchange or deposit cryptocurrencies or other virtual currencies in U.S. currencies for money. This would require those virtual currency kiosk operators to be licensed under the Kansas Money Transmission Act. It establishes certain disclosures that have to be provided to customers prior to entering into transactions at the kiosk. And then also incorporates various anti-fraud measures relating to those transactions. Does set limits on the direct and indirect charges, including the spread fees. And then it does place some limitations on the total amount of transactions and governs refund procedures. Then also authorizes the Attorney General Office or any law enforcement agency to investigate any fraudulent money transmission under the Money Transmission Act, not just the, including but not limited to this, the kiosk. It'd be any Money Transmission Act. Then I'll update some definitions for two-party exchange, three-party exchange to reflect how those are handled under the kiosk transactions.
Thank you for that, David. Committee, do we have any questions for David? Seeing none, do we have any amendments? Representative Sweeley.
Thank you, Mr. Chairman. I would offer an amendment on behalf of the Attorney General's office. If you're looking at the bill, it'd be on page 8. There'd be 2 little small changes.
I think David's, or Rich, are we getting that distributed out?
I'll wait.
Yeah, you can go ahead and explain it while it's getting sent out.
If you're looking at the exact bill, on page 8, about halfway down, there's section 1 on line 22. It'd be adding in a second section clarifying for the initial transaction only and up to $2,000 for that transaction limit. And then also almost all the way down to the bottom of the page 8 on line 40, it would be section B, it'd be submits to such virtual currency kiosk operator a police report or a sworn declaration. And that would be the only 2 things that are changing. And if David needs to explain it a little bit better than I can, then go ahead.
Okay. And Rich we're getting that email sent? Okay, should be in your. And Representative, you said that this was on behalf of, this is what the AG's office had recommended last.
On behalf of the Attorney General's office, yes. And I have a physical copy if anyone needs to see it in person.
And David, can we just get a brief explanation too, just kind of what it is?
Yeah, thank you, Mr. Chairman. Yes, I think Representative Sweeley hit it pretty right on the, so on the first balloon there would be on page 8, line 22. This would then clarify that the initial transaction is capped at $2,000. It would then retain the remaining limitations there in that first 14 days. Just the one transaction within 72 hours, and then a maximum of 10 within that first 14 days. And then after the 14 days, it'd be up to $10,500 per day. But there was some concern that it wasn't clear that the initial transaction was capped at $2,000. This would say it's capped at $2,000. And then for the sworn declaration, this is for the refund from existing customers when for those spread fees, those indirect and direct charges. To require that to have a police report or sworn declaration. This would align the language that's in subsection D with what is currently in the bill in subsection E for when we're requesting refunds under that section on the initial transaction.
Committee, are there any questions on the amendment? I see none. I do need a second on the amendment. Vice Chair Steen seconds the amendment. Any discussion? Seeing none, Representative Sweeley, you can close.
I close.
All in favor of the amendment, say aye. Aye. All opposed? Motion passes. We're back on the bill. Do we have any discussion or further amendments? I see none. Representative Shu.
Mostly I just wanted to thank the chair for taking this on. I know this is a big issue and it was kind of a heavy lift putting everything together on this, but I think this is a true issue, and putting guardrails on these is important, and I am just fine with where the fee caps are on this bill.
Thank you for that. Committee, yeah, no, I appreciate that. A lot of work did it go into this bill from both sides, really. Crypto industry was great to work with. And the proponents of the bill, I did last week neglect inadvertently to mention AARP and the help that they provided as well. So I do want to thank them for that. They were instrumental pushing this in Kansas. They've also brought it up in other states too. So I've appreciated their help. But it's a good piece of legislation and it's something that we really, really need to address. So with that, do we have any further discussion? Seeing none, Vice Chair Steens for a motion.
Thank you, Mr. Chair. Yes, I move that we pass House Bill number 2515 out of committee as amended.
Do I have a second? Second by Representative Bohai. Any discussion on the motion? Seeing none, all in favor, aye?
Aye.
All opposed? Motion passes. Committee, that's all the work we have today. I do intend to work as long as everything's fine. 2590, the trust bill we heard today, do intend on working that Wednesday as everything goes to plan. If you have any further questions on it, feel free to reach out to me. Will, we know how to contact him as well. He mentioned today about all the great employees he has, and I'd say 99.9% of those employees are probably pulling their weight there. But there's one employee I suspect is a slacker, but we'll discuss that at a different time. So with that, committee, we are adjourned.